Good morning, everyone. Welcome to today's webinar brought to you by the MEP of Louisiana and Ogletree Deakins Law Firm. I am Kayla Gentry, the Manufacturing Outreach Manager for the MEP of Louisiana. And as you can see, today's topic is legal aspects of the COVID-19 vaccination for employers. We have a presentation today by Attorney Andrew Halverson of Ogletree Deakins, and please be on the lookout for our upcoming webinars each month from the MEP of Louisiana. So real quick, I know you guys are anxious to get started, but I'm going to go over a little bit of housekeeping. I know that there will probably be quite a good bit of questions for this webinar, so please put your questions in the question box on your little side panel there, and we will get to them at the end of the webinar after the presentation. So you'll definitely have an opportunity to ask questions. This is a live webinar event which will be recorded. We have a YouTube channel and you should be able to access the webinar there. If you want to send the link to someone who wasn't able to join, you will have access to that. I hope to get that up within a couple days. So before we get started, I do want to give you a little bit of information about, the MEP of Louisiana and who we are. So the LCTCS MEP of LA, that's Manufacturing Extension Partnership of Louisiana, partners with colleges in the system to complete the mission of the MEP National Network. The Manufacturing Extension Partnership is part of a national network under the National Institute of Standards and Technology, or NIST, that works with U.S. manufacturers to create and retain jobs, increase profits, save time and money, develop new customers, and expand into new markets. MEP Louisiana is also part of the Louisiana and Community Technical College System, or LCTCS. As such, we're better able to cover the state of Louisiana as a whole, with project managers located at community colleges throughout the state. The community colleges with the MEP of Louisiana offer services to manufacturers, which help to meet the advanced needs of the manufacturing industry and produce a highly skilled and reliable workforce. So I know you guys really want to get to today's topic. I'm very interested as well. So I want to go ahead and introduce our presenter. Again, today's webinar will be presented by Andrew Halverson of Ogletree Deakins Law Firm. Andrew brings more than a decade of wide-ranging legal experience on matters across the spectrum in general business and corporate, mineral, property, and employment law. Originally from Anchorage, Alaska, Mr. Halverson completed his undergraduate and graduate degrees in mathematics at the University of Louisiana at Lafayette. Mr. Halverson received his Juris Doctorate and Bachelor's of Civil Law from the Paul M. Hebert Law Center at LSU in 2007, where he served with honors on the Toulouse Moot Court Board and was also a member of LSU's National Mock Trial Team. Mr. Halverson is licensed to practice in all state and federal courts in Louisiana. And so I'll go ahead and pass it over to our presenter who will walk you through the legal aspects of COVID-19 vaccinations. And Andrew, I'm so glad you're able to join us today. I'm going to go ahead and change it over to you. You should have access to the screen once I do this.
Okay. I think so. Oh, yep, that's in the presenter. So, and I hit, Kayla, I'm sorry, you have to refresh my memory.
Okay. Go ahead and hit, you should be able to hit that top tab. Sorry, I'm looking for it on my end. Okay.
That right there?
Yep, we should be there.
Okay. Okay, good. Well, I appreciate it. And Kayla, just want to check with you. You can see the slide presentation here.
Yes.
Okay, good. All right. Well, good morning, soon to be afternoon. Welcome to the first day of fall in Louisiana. We just ended second summer yesterday, so that was I'm excited about that. And Kayla, I appreciate the introduction. Now you all know that I was a super nerd, super geek prior to going to law school with my background in math. that kind of makes me I was definitely unique in law school for that. I want to thank you for having me here. Let me present to you and joining me this morning. I'm with the firm Ogletree Deakins. We are a nationwide labor and employment law firm, and I work out of the firm's office in Lafayette and also connected to the New Orleans office too. Okay, so
Andrew, I just want to make sure that that everyone can see your screen. I'm going to pass it back over to myself and then pass it back over to me because I'm not seeing it on my end.
Okay.
So let me pass it back over to you. Okay. Are you able to share your screen at that point?
Yeah, I guess my apologies. Where am I looking for that?
That's okay. You should have an option to share your screen, correct? Under the sharing button.
Is that it right there? Oops. I think my apologies. I think I just hit a button to tap it away. Let's see. Can you hear me okay?
Yes, I can hear you.
Okay. So looks like maybe I don't. Let me see if I can figure it out here. Nope, that's still okay.
Yes.
Oh, show screen, main monitor. So can you see it now?
That's it. You got it.
Okay. Good. I found it.
And go ahead and hit your little the little present button at the very top left-hand corner.
Right there.
You could hit that button. And then hit display settings at the top tab and hit
swap.
There you go. You got it. That's your presentation.
Okay, good. All right. Well, thank you for bearing with us on my technical abilities there. So let's dive right on in. What we're here to discuss the question: can employers mandate vaccination? And really, that's an easy question unto itself, but it raises a whole host of related questions after that. So we'll talk about the vaccine mandate, whether it's possible, and then also exceptions to the policy, documentation of the of vaccination, and then some other basically some legal liability issues that may pop up for in the employment context for the employer relating to mandated vaccines. So, like I said, it was an easy question. The EEOC has sort of given us guidance on this already, but actually these policies are very old. There's been other pandemics through the course of the last century, and so the EEOC has had opportunity to opine on this for quite a while. They update their guidance routinely. You'll see here May 28th, but actually they updated it this Monday. So, but the short answer to the question is can employers mandate that all their employees be vaccinated? The answer is yes. The only limitation to that is that you do have to make accommodations for those who maybe have a medical disability or who hold a sincerely held religious belief, practice, or observance that may require some sort of exception or exemption. And so really that's sort of the thrust of this presentation is how do you handle those requests? How do you identify a request? How do you handle the request along the way? Because that can be not a complicated process, but it definitely can. It's rife with sort of pitfalls. One thing to note before we get into anything dealing with accommodations is that if an employer mandates that its employees be vaccinated, nothing wrong with that. But what you want to do is you want to monitor the results. Monitor who among your employees are getting vaccinated and who's not getting vaccinated, and specifically monitor for disparate impact. You could have a neutral policy, everybody get vaccinated, but the effects of that policy could fall disproportionately on one group over another. And if that disproportionate effect is felt by a group that is protected class, race, religion, sex, then that could raise Title VII concerns, discrimination concerns. So monitor it as the policy is being implemented. Sort of keep track of the statistics, who's being impacted, what groups are being impacted, and who's not, just so that you can also maintain compliance along the way. So the federal law says yes, you can. What does Louisiana law say? Easy answer there too. Louisiana does not have a separate statute or anything, or even regulation or executive order from the governor. Nothing mandating vaccines be provided or prohibiting employers from mandating vaccines. So in other words, whatever is permissible under federal law would also be permissible under Louisiana law. Now, I say that the legislature may act on that. They tried it in the last legislative session to outlaw vaccine mandates. It didn't pass either the House or the Senate. So they were unsuccessful, but we know that Texas is brewing with some legal activity on mandates, and so maybe there will be some impact that will come over to Louisiana too. But until we get a change of governor, I don't see anything happening on that anyways. Okay, so what's the state of legal challenges? There are employers that have already mandated that their employees be vaccinated, and you'll see two healthcare systems, Lourdes and Oxnard. The reason for that is because back some months ago, OSHA issued a standard for healthcare, the healthcare industry, mandating that their employees either be vaccinated or be tested regularly or receive a negative COVID-19 test. So that's why you see hospitals sort of at the forefront of all these legal challenges. Sort of a quick summary. Right now, one of the suits against Oxnard has been dismissed. But the one against Lourdes is still ongoing. But the lesson from both of those is that the judges in each of those cases said the policy itself is fine. There's nothing wrong with having an employer-mandated vaccine policy. It's permissible under federal and state law. Where the judges are sort of raising questions is how is that policy being implemented? Specifically, is it going to violate some other rule? Discrimination rule is probably the biggest hurdle that they'll have to cross. But the point is the policy itself, nothing wrong with it. It's all in how companies, particularly these healthcare providers, are going to implement the policy. And that's sort of future, because really no one has been impacted by the policies just yet. No one's been terminated. But that issue will come to a head soon. So, keep watching the news, but as of this moment, the challenge itself is not to the policy, it's implementation. We all know that from a federal standpoint, President Biden issued his executive order relating to employers with 100 or more employees under the OSHA standard, the emergency temporary standard. That policy hasn't been issued yet. It's with the White House right now for approval, but we think it's going to look a lot like the healthcare ETS that was issued a couple months ago. So the policy under that OSHA standard, the ETS standard, is that employees either be fully vaccinated or that they receive weekly negative COVID-19 tests. It seems kind of sort of a reasonable compromise if an employee is not going to get vaccinated, get tested, get negative tests. At least that's what my wife tells me, to say, hey, why don't we do this? And so let me answer the question. Why aren't employers allowing employees to just offer up negative COVID-19 tests? Is because in Louisiana, you have to, as the employer, they have to pay for that test. And so if you have a significant number of employees who are declining a vaccine and you have to pay for those COVID-19 tests, that can add up real quick. And so there's all sorts of business considerations as to why an employer would institute a mandatory vaccine policy. Cost is but one issue, but it could, for depending on the size of the business, it could be a sizable issue in the number of employees declining vaccination. So it is a consideration. There will be pushback. You've already seen the Texas governor issue that executive order saying he's not allowing any companies in Texas to require their employees to be vaccinated. That's going to come in direct conflict with the OSHA ETS. And it raises all sorts of constitutional issues, supremacy clause, Article 10 of the Bill of Rights, We could have a separate discussion on that altogether, but it's sort of just more to come. We don't know, we could all make bets on how it's going to go, but it's kind of more to watch. But private companies, which is kind of interesting, I think it was Delta's CEO, maybe one of the airlines, maybe I'm not right on Delta, but he said, we're not going to comply with the OSHA ETS standard either. So there is pushback in the business community. Don't know how it goes. I don't know how many folks here are impacted by that. But the point is when you see it applied to the large companies like that, it's usually sort of a stepping stone to smaller and smaller companies too. So do keep an eye out for that. So if your company you decide as a company to institute a mandatory vaccine policy, the recommendation is to really have a dialogue. You don't have to necessarily explain all the ins and outs of the company decision for that, but what the EEOC recommends is sort of a dialogue with employees as to the benefits of vaccination and also the risks of remaining unvaccinated. And the Delta variant sort of exposed that for us. Is those with the vaccine had a much lower risk of hospitalization and severe or significant impact from COVID, whereas unvaccinated folks, even younger kids, had a significant higher risk of having to be hospitalized and even ventilated. So that's where the communication kind of comes into play. Options for vaccination, you can inform them. There's vaccine. There's places where you can get vaccine all over the place now. So that's pretty easy to find. But there are government resources. You can go to vaccine.org to find locations, or you can call the CDC. Have your employees call the CDC, and they can also inform them as to where they can get vaccinated. One thing you want to do, though, it's not on the slide here, and I forgot to put it, is that if a company does institute a mandatory vaccine policy, they would want to inform their employees of who they can contact within the company, a representative, if you will, who can handle accommodation requests. And that person that is designated to receive accommodation requests should also be trained to spot and identify whether an employee is making a request and what type of request it is. And the reason for that is because requests for accommodation, it can be oral or it can be written. There's no magic phrase or buzzwords that the employee needs to use. And so someone needs to be mindful and kind of aware of what type of accommodation is being requested, medical or religious. And so on that note, well, we'll go there in a second, but once the employer has mandated vaccines, communicated it, and employees start going through the vaccination process, or maybe they already have, how are you going to get proof of vaccination? And just there's a myriad of ways that you can document whether an employee's been vaccinated. But one thing to take note of right away is that whatever records the employer receives relating to vaccination are confidential records, and you want to keep those separate and apart from the regular employee personnel file. And this extends not only to vaccination status. The separate confidential file would also be a place where you put accommodation requests. Would also be if someone got contracted COVID, you would keep that information in that separate file. It's confidential. If they have symptoms of COVID, if they have an accommodation request, or if they actually receive an accommodation, all of that information needs to be kept separate and kept confidential. So you also want to sort of limit the number of people who have access to those records. Maybe one or a few people within your HR department would probably be where you want to limit that to. So in terms of documentation, how would you as the employer establish whether an employee has or has not been vaccinated? What a lot of employers were doing sort of early on when the vaccine was being rolled out was they were hosting sort of vaccine, employees being vaccinated at the facility. That's sort of become less and less, as I've seen it at least. What now, because of the wide availability of vaccines, you can go to the hospital routinely, maybe even I think Walgreens does it too. So those employer vaccination campaigns are not as common anymore. So what then the employee would receive is maybe a vaccination card from the healthcare provider that they got the vaccine from. Just be mindful, I mentioned it here as sort of a side note. We have seen, it's come across my desk a few times, forged or fraudulent vaccination cards. just keep an eye out for it. It doesn't mean that you have to police it. Doesn't mean you even have to report it, but just do know that they are aware. So what we've been telling clients is that maybe communicate on the front end saying, hey, don't get these offline, don't get forged ones, because it is a federal crime. The FBI has advised getting a forged vaccine card is a violation of federal law. And there's real penalties attached to it too. Two other things: attestation. Can the employee attest to you, the employer, that they have received the COVID-19 vaccine? That's permissible in some settings, particularly in a healthcare facility under the OSHA ETS there. That comes with its own risks, but it may be possible, and so maybe something to consider as well. But also I wanted to add here, take a look at your cell phone apps. Where's my phone now? My phone right here. I have the LA Wallet app on my phone where I keep my driver's license, and I found out the other day that it also had my vaccine status. I got the vaccine, and it has a little check or something there saying vaccinated. And so that kind of follows up if an employee ever loses the vaccine card, if they have a smartphone, iPhone or some other smartphone, they could download the LA Wallet app, and it would have that information because the Louisiana Department of Health imports that into the LA Wallet app as well. So it's sort of a backup, if you will. But on that note, if an employee ever loses their vaccine card, they can go back to that employer, the site where they got the vaccine, or they can go to the Louisiana Department of Health and they can get a replacement card. That is very possible. Okay, so let's talk about the exemptions to mandatory vaccine policies. Excuse me. So there are only two limited exemptions. One is a medical disability exemption under the Americans with Disabilities Act, or it's an exemption for sincerely held religious belief, practice, or observance under Title VII of the Equal Employment Laws. If you have an employee who doesn't fit under either one of those exemptions and they choose to remain unvaccinated, then termination of those employees does become an option. You could also, for those employees, choose to engage in the accommodations process, the interactive process, but it's not mandatory is what we're saying. So it's only mandatory to engage in the accommodation process if they fit in a medical disability or as a sincerely held religious belief. Excuse me. So when we talk about medical disabilities, what are we talking about? Well, there's no one size fits all sort of, this is always going to be a medical disability or not. You have to make it individual, tailored. You have to talk with the employee, get information from them as to the circumstances of their medical disability. Why is it that they can't get this vaccine? Have they gotten other vaccines? Things of that nature. Oops. Okay, looks like maybe just clicked off there. Okay, so some things that have popped up as possible medical disabilities. Hold on just a moment, it's kind of flickering on my end. Let me. Oh, pardon me, I think it's, there we go. My background screen was popping up for some reason. Okay, so some things really, it's talking about maybe you have.
Hey Andrew, sorry, you may want to hit resume slideshow. It's showing your main slide, your first slide there in the PowerPoint.
Oh, okay, let's see.
Do you see the little resume slideshow button?
I think so. Not really. Is it on the little tab?
It's on the top of your the header of the PowerPoint program.
Okay, I think.
So it's showing us your PowerPoint program there. There we go. And then just click your full screen.
This right here?
Yeah. Oh, no. I think it's the one next to it, Andrew. No. On the other side, the left-hand side. There you go. That one.
Okay.
All right.
Is that it?
You'll have to, looks like you'll have to switch back to that swap presenter.
That's right, thank you.
Okay, and then maybe click through, sorry.
No, you're
Not
good.
sure why it's flickering on your end.
Okay. So what we're looking at with medical disabilities, um, allergies, maybe an immune system issue, maybe they can't handle vaccines. That was actually the subject of a Supreme Court case back about 100 years ago, where someone had actually problems with vaccines, and so they tried to get a medical disability. This was way before the ADA, but it is possible, is what I'm saying. So, but the point is that you want to do an individualized inquiry as to the medical condition and what's going on, what's going on with this vaccine that maybe they can't get it. One issue that pops up with medical disabilities is the question of pregnancy. Pregnancy in and of itself is not a medical disability under the ADA. And so for that reason, the CDC recommends that pregnant women, women wanting to become pregnant, women who are breastfeeding, they all get vaccinated. So pregnancy and pregnancy, just sort of related condition itself is not an exemption under an exemption to an employer vaccine policy. Now, there could be pregnancy-related conditions like eclampsia or some other, that's the only one I can think of off the top of my head, but other pregnancy-related conditions that could qualify as a medical disability under the ADA. But pregnancy in and of itself is not a disability. So just kind of be mindful of that. And when you talk about pregnancy, also we have to keep Title VII in mind, because rolled into Title VII is the Pregnancy Discrimination Act. So what that basically in a nutshell says is that when you have pregnant workers, pregnant employees, they can't be treated any differently from their non-pregnant counterparts. So if you're making an accommodation for a man or a woman who's not pregnant, you need to make that accommodation should be on the table as well for women who are pregnant. So be mindful of that. And my sort of recommendation is when it comes to pregnant women who are asking for an accommodation, just avoid any sort of evaluation of whether they're pregnant, desiring, or currently breastfeeding. Take that out of the analysis altogether and just treat them as though they weren't pregnant. And that'll sort of lead you down the right path. So the other part of it is the religious belief exemption. This is an exemption is a religious exemption that they hold sincerely. Well, let me say it this way: it's a belief, religious belief, practice, or observance that they hold sincerely. The burden is really on the employee to establish that it is a religious-based belief, practice, or observance, and that it's sincerely held. If the employee establishes that, then the employer is under an obligation to find an accommodation, or if it can't, express why it's an undue hardship. So let me talk about the first part of it, the employee's obligation to establish a religious belief that's sincerely held. Those are potential minefields, is because it's such a subjective standard sometimes. The definition of religion under Title VII is a very broad definition, and it could include religious beliefs or religious practices that are sort of unfamiliar to the person receiving the information. So you can't judge whether something is or is not a religious belief based upon your own religious beliefs or non-beliefs, as the case may be. And so the EEOC, sort of recognizing that there may be there's religion casts a wide net, sort of advises that the employer just go ahead and take the employer's word for it. Assume that it is religious-based belief, practice, or observance, and then go from there. The next part of it, though, is whether it's sincerely held. You look at things as whether you look at things as whether the employee is acting in a manner consistent with that religious belief or practice. How new is it? Now, again, these can be subjective-based standards, and so again, it's kind of fraught with fraud as a minefield. So the EEOC has recommended to say that go ahead and assume that it is a religious belief and that it is sincerely held, because even a new belief will still qualify for the exemption. Where the EEOC has sort of guided us and said what they prefer everyone to do is to focus on the accommodation, the interactive process. If someone raises a religious belief, is there an accommodation that could accommodate that belief or practice? That's where that's more objective based, and it gets the employer involved and able to document the whole thing. So there may be an accommodation also. One of the things that the EEOC raised as a possibility is that there are some vaccines that people have objected to on religious grounds, and other vaccines that people have not objected to. I think the J&J, the Johnson & Johnson vaccine, I think is one because it used, I don't know, I actually don't know which one, but there was one of them that I've seen regularly objected to on religious grounds because I think just the way that they developed the vaccine has raised the objection. So they could be waiting for another vaccine. Maybe they live in a community, this is sort of early on where one vaccine was available, but the other one wasn't. So if that's sort of the request that the employee makes, that may be reasonable. It's particularly now that the vaccines are so widespread. But there could be a preference for one vaccine over the other. When we talk about the accommodations process, that is an interactive process. Learn about what the basis for their accommodations request, disability, medical disability, or religious belief. Learn about it. What is it about the vaccine that conflicts with either their religious belief or conflicts with their medical condition? And also as part of the employer's aspect, when you do the undue hardship analysis, you also want to look at your workforce. How many employees are vaccinated? How many are not vaccinated? But also look at that employee. It's a very individualized assessment. What's the conditions of the employee's day-to-day work experience? What are their job duties? Who do they interact with? Do they work in an office that's enclosed and they don't have anyone around? Or are they coming into regular and routine contact on a continual basis with coworkers, with customers, with vendors? So the nature of the accommodation oftentimes depends upon the nature of the position that the employee is then working in. So as part of that, the employer can rely upon the CDC recommendations and guidance for what would be undue or what would be appropriate. And so kind of on that, some accommodations that are maybe possible. This is not the panoply, this is not the universe of accommodations, but these are some that you could easily incorporate, possible at least, is wearing requiring unvaccinated employees to wear face masks. By the way, if you're a federal contractor, you got to do that anyways. So I'm really more speaking to the non-federal contractor sort of context. You could require unvaccinated employees to wear face masks. You could require social distancing. Not always possible, but if it is possible, you could offer that as an accommodation. Modified shifts. Maybe the employee can come in or work later, when they're not in so much contact with everybody else, with the customers or other employees. Testing is an option, but just also be mindful that if testing is the accommodation, then the employer picks up the bill for those tests. And so that leads us to the final two bullet points of whether telework, remote work is a possible accommodation, or whether reassignment is. And that's possible, but again, you have to explore, are there other accommodations? Because telework, while possible, I think the goal behind the accommodation process is to keep the employee within the community of the workplace as much as you can, and not to isolate them unless it's kind of just absolutely you have to do it. So telework is an option, but you want to make it sort of one of your last options. And then if telework is not a possibility, then you can also consider as a last resort whether the employee can just be reassigned to a different position altogether. Maybe there's not a position, we'll talk about that in a second, but if there is a possible for reassignment, then you could explore that as well. But that's actually a last resort. So these are just but some suggestions. I give you a website here for the Job Accommodations Network. That's a good resource to help employers and employees to identify possible accommodations, and it's got it by industry, position, and all that. So it's a very good resource. Check that out. So this, exclusion from the workplace as an accommodation, I kind of talked about this already, is that you really have to make an assessment, an individualized assessment on the employee's position, interaction with kind of a day-to-day interaction. And really, the point of this slide is just to reinforce the idea of documentation. When you're going through the accommodations process as an employer, you want to document as much as you can. Because if it gets challenged later on, then you have that sort of at the ready to show sort of your analysis, what you decided upon eventually as the accommodation. On that note, before I leave this accommodation, not this particular one, but it could be possible that you have multiple accommodations that would work. Wearing a mask, social distancing, telework, who knows? The employee may have a preferred accommodation, but the employer is under no obligation to accept the employee's desired accommodation. The employer, at the end of the day, the EEOC hopes that the employer is taking the employee's request into consideration, but at the end of the day, the employer gets to make the decision. If there's multiple accommodations that would work to satisfy the accommodation request, then the employer gets to choose the one that is best for the running of its business. So do be mindful of that as well, that you ultimately have control there. Okay, if an employee is excluded from the workplace, maybe they're assigned to work remotely, that's not the same as termination. They're still employees. All the rules apply as if they're there in the workplace. It's just that they're not there. So when does it come to termination? It's basically if there's no accommodation that would, or let's say that if all the accommodations, possible accommodations, would be an undue hardship on the employer, then at that point, the employer can consider terminating the employee. And this is where documentation really comes into play, so that you can support the decision to terminate an employee who qualifies for an exemption of medical disability or sincerely held religious belief, but nonetheless is terminated because the employer cannot accommodate the request. So what does it mean to be an undue hardship? When does an accommodation become undue, too much for the employer? And the thing to note is that the standard for it really depends upon the request, the accommodation request. If it's a medical disability under the ADA, the undue hardship means a significant burden or expense. And so not just a little bit, but a lot. And it sort of depends upon the size of the business and the situation and the relative sort of individualized analysis of that particular employee. But say, for example, you have an employee whose desk is normally in a common area where it's just easily accessible, people passing by, and the only accommodation is to build them a separate office on their own. That's a significant expense on the employer's part to have to accommodate that one employee. So that could probably fit under the ADA. But that's what we're looking for, is this sort of really difficult or really significant expense imposed upon the employer to accommodate the employee. Under Title VII, it's a much lower standard. The undue hardship in the Title VII context, and remember what we're talking about, Title VII applies to the religious, sincerely held religious belief exception. When you have that sort of as a basis, then it's really just, is the accommodation, does it have a minimal or a minimal cost or a minimal burden? What could that mean? That could mean things that it increases maybe a safety hazard at the workplace, even if it's just a little bit. It could also mean that your other workers maybe are overburdened. Maybe their work becomes more burdensome because of the accommodations afforded to the exempted employee. What you want to do in both contexts, but definitely in the Title VII context, religious-based exemption, is you want to document. It needs to be based upon objective standards. You can't just assume or speculate that this is going to cost you a lot. You actually have to go through an analysis and base it upon something objective to say, here's what it's going to cost, here's what it's going to do. Document it as best you can as well. Okay, I had one other note, but it kind of left my brain, so I'll move on. Okay, so you have you've gone through the accommodations process, you've instituted a vaccine policy, so now you're after the decision. What's life like? Well, it kind of depends upon what the orders, the governmental orders are. You know, here in Louisiana, the governor just, yesterday or 2 days ago, just lifted the mask mandate. So we're not under the order anymore. So then you would have to look at your local government. New Orleans right now is still under the mask mandate, though I hear chirping that Mayor Cantrell could be lifting that for New Orleans pretty soon. But right now it's still in existence. So you have to monitor that. So if you're in the New Orleans area, even if your employees are vaccinated, you got to go to Mayor Cantrell's order and see if it still requires masking, social distancing, occupancy limits, all that jazz. So that's really sort of the big deal here, is that you always want to keep up with what are the governmental orders at the end of the day, because we'll talk about in a few moments, that really does sort of play into the liability of the company. Are you following those mandates? Do the mandates apply? If so, are you following them? And if you're not, what's the risk associated with that? There are some legal liability implications for that as well. Okay, one thing to take note of is the ADA and also the GINA, the Genetic Information Non-Discrimination Act. Those acts also really try to protect employee information related to their medical condition or their genetic information. Asking about a vaccine and asking about proof of vaccine is not a medical examination under the ADA or even GINA, the Genetic Information Non-Discrimination Act. So that is certainly permissible. But if you're seeking more information beyond just vaccine status, be mindful. Because you could be asking questions that would elicit medical information, and then all of a sudden you're engaging into a medical examination, which could opens up a whole lot more doors under both the ADA and GINA. So sometimes you need to ask those questions, and so if you ask those questions, what do you do with it? That's kind of where we're going with this. So if you're gonna, as an employer, if an employer is going to mandate vaccines for their workforce, one of the things you want to know is well, what's the current status? You know, are we vaccinated? Or are we not vaccinated? But what goes with that then is when it's time to get the vaccine, is you got to ask questions. You know, when I got my vaccine, I got the same questions. You know, are you allergic? All these things. Those questions about a person's medical condition or health condition or even genetics in their family history are pre-screening questions that could constitute medical examinations. That's not as common anymore. This was really a big deal, a big deal when employers were hosting vaccination, you know, at their facility. If you're having an employee go out to, say, you know, the hospital or Walgreens or so, you know, if you're kind of letting the employee determine where they're going to get their vaccine, pre-screening questions are not as big of a deal. But if you're hosting vaccination on site, then you would want to be mindful that questions you ask in connection with getting the vaccine could be a medical examination under the ADA. And so what that means then is that if you're hosting those sort of vaccine events at your facility, an employer does that, then you would have to demonstrate that the vaccine is necessary and job related, that it's consistent with the business necessity, and has some objectivity as well to it. So, and then also that the employee presents a direct threat to his health or safety, the health and safety of others on the workforce. So, because a lot of these questions, these pre-screening questions, raise some sort of heightened risk under the ADA, that's why, and with the availability of the vaccines at different places. This has become less and less of a concern as time has gone on. Okay, considerations under GINA right quick. There's one big deal here. GINA is the Genetic Information Non-Discrimination Act. I mentioned it before that administering a vaccine, asking about whether they've been vaccinated, not a problem under GINA. Where I think a big minefield is under GINA is mandating your employees' families to be vaccinated. As the employer, you can mandate that your employees be vaccinated, but you cannot mandate, as the employers cannot mandate that their family members be vaccinated. That would be a violation of GINA. Also a violation of GINA is to penalize an employee if their family member is not vaccinated. So that presents its own challenges too, which is sort of interesting because one of the things that we've seen, it was popularized, I think, by not Delta, one of the other airlines, where they started charging employees who have family members who are not vaccinated, charging them more on their insurance premiums. That's not really a penalty. That's just sort of understanding the business, cost has risen because some people are covered under their policies or not vaccinated. So they're just sort of transferring that cost. So so that is sort of it's not a penalty per se, but it is an increased cost that is passed along to the employee that would be okay under GINA. Sort of the same thing here. Whenever you're asking questions, make sure that it doesn't elicit medical information. If it does, it has to be satisfy the business necessity. Has to be you just have to be careful with the information. And whatever information you do receive of a medical nature or even genetic nature, keep it in a confidential, separate file away from their personnel file. I think I've mentioned this a couple of times. Inquiring into vaccine status is perfectly fine. No issues with that. Hipaa, that's the Health and Human Services provided the standards here. Basically, Hipaa is the privacy rule that when you go to your doctor, they're under HIPAA compliance, that they have to maintain the confidentiality of it. But it's also more about publishing it to third persons. Who can they publish it to? Who can they not? And the sort of levels of protection with that. So when we're talking about healthcare providers, employers are not healthcare providers under HIPAA. So you're not really covered by HIPAA. So that's just one thing to be noted of. But all those confidentiality issues are under the ADA. So that, and under GINA as well. So that's just something to be mindful. It's a little side note here. But where we want to go to now is suppose, well, let's take a look at employer liability with respect to vaccination and also with respect to COVID-19, infection from COVID-19. Let's talk about the vaccine first. There are side effects with vaccines, and there could be major complications. The very few who have them, there could be significant complications to the vaccine. And if an employee gets a vaccine because of an employer mandate, that then opens the door. Well, is the employer responsible for that person's damages? Maybe they got very sick and had to go to the hospital, or worse yet, who knows, maybe they passed away. But the point is what's the employer's responsibility, legal liability, with respect to an injured employee? And if it comes from a vaccine, then the employer is covered under Louisiana's worker compensation. In other words, workers' comp provides the exclusive remedy. If an employee is vaccinated because of injured from a vaccine because of an employer mandate, workers' comp would step in and say, you can be compensated, but it's going to be subject to the rules and the limitations of workers' comp. If it's injuries to anybody else, or if it's injuries related to anything else besides the vaccine, then we would have Louisiana's tort law come into play, which will be called personal injury law. And so you would have to do the traditional tort analysis. But early on in the pandemic, I think in March or April of 2020, the Louisiana legislature passed, and I have the title of the act here, the limitation of liability for COVID-19. That's the name of the statute. It basically says that no person or business is liable for injury or death resulting from the exposure to COVID-19 through the performance of their regular business operations, unless, and this is where those government mandates come back into play, unless they fail to substantially comply with at least one set of procedures, either under federal, state, or local, whatever mandate applies. If the employer fails to follow at least one of those sets of procedures, they could open themselves up to liability for injury related to COVID-19. Someone contracts COVID and maybe has a significant bout of it, hospitalization or whatnot. So if the employer fails to substantially comply with the order and the injury was caused by gross negligence or what we call reckless misconduct, that's a pretty high standard. So you really have to, be flouting the law, if you will, to open yourself up to liability for this. So the general rule is what this law did for us, did for employers, and did really for everybody early on in the pandemic is to say, is to give a nice broad shield to liability for COVID-19 related injuries, including death. And the only way that someone, a person, or a business becomes responsible is if they don't follow the rules and they did it with sort of a reckless disregard for people's safety. And so when you go around businesses, I live in Lafayette, and quite common to see businesses not enforcing the mask mandate, not enforcing early on social distancing and all that stuff. The question really was, they were certainly violating governmental mandates, particularly with the social distancing part of it. Was it gross negligence? Was it reckless misconduct? There were some restaurants in Lafayette that I saw that were definitely, it was gross negligence and reckless misconduct. So because they were super spreader events back then. So the world has changed with COVID, even in that year and a half since then. But that's sort of a two-part thing. Are you following the rules? And if not, is the reason you're not following the rules because of your own gross negligence or reckless misconduct? So do know that nice shield is out there for you, but that's why employers have to be mindful of what are the operative mandates going on. Say if you're in New Orleans, or the state mandates, because those help to determine whether the shield for liability is maintained throughout. Okay, so this is sort of just reinforces what I just said. By the way, one thing I didn't mention is while you have to stay abreast of the COVID-19 procedures, CDC, state mandates, and whatnot, compliance. One of the things that we do in my office here is we have a sign-in sheet. We have people who come into the office, we get them to sign their name, who they're here to see. But when they do that, we have them sign a piece of paper. Hey, here's our policy. You have to mask up. You have to be vaccinated. Whatever the policy is, I actually don't know from my firm. But the point is they document it. They document who's coming in, what they're doing, all that stuff, and documenting that the business is complying with the governmental mandate. So that's one of the things. It could be a lot, but it could help you in the long run. So that if someone contracts COVID and they say, I got it from someone at the facility, then you can say, well, I told you to wear a mask. You did wear a mask. All these things. You can document the employer can document their efforts to comply with the standards at the time. Okay, so what about people, coworkers or customers who are vaccinated themselves, but they don't want to come into contact with unvaccinated employees? And sort of the scenario that we have here, just to kind of the setup, is we're operating under the assumption that the employer has mandated everyone in their employees to become vaccinated. So by this point, you have employees who are unvaccinated. It's because of some sort of accommodation, religious, medical disability, or sincerely held religious belief. And so hopefully you've accommodated that to not only, really the accommodation is to what shield the other coworkers or the customers who may come into contact. So hopefully it's mitigated and minimized as much as it can. But really, at the end of the day, as long as the employer's following the rules of, you're following Title VII and ADA, Title VII and ADA, we're good.
Good, Andrew. Go ahead and
Okay. No. As long as you're following the rules, the employees can't really refuse to not work with someone or refuse to not interact with unvaccinated. At the end of the day, they are an employee of the company, and so they can be they can't not choose to do that. They have to still do their job. But the hope is that the employer is following the policies, following the mandates, and minimizing the risk as much as possible through the accommodations process. I think that was my last slide. So I appreciate the time and being with me and allowing me to be with you. I think we have, Kayla, is it time for questions?
Yes, and I realize we are at the 12:30 mark, but I felt like especially the last couple slides were pertinent information. So for those of you that can stay with us longer than the 12:30 mark, we are going to address some of the questions from the audience. So I'm going to go ahead and get to it. What sorts of documentation is required for medical disabilities or for religious exemptions?
There's not a one size fits all sort of here's what it is. I think I'm sure my firm has some resources that we could pull down, but really what it is it's documentation of the well, let's take medical, let's take religious. I think at that, when I think of the religious exemption, that's really more just an interview. Here's my policy. Maybe that you could get there, the pastor or the priest involved with here's the standard for our our church or our religious. So maybe you can get a statement from the from a religious sort of their pastor or priest. That's a little hard to document in terms of what it is the request is. Where the documentation probably comes more into play is what the accommodation is or what's been offered in terms of an accommodation. So there, it's probably just a simple, simple homemade form. You could say, we offered this, and you have them sign an acknowledgement. This is the accommodation that we've offered. Did the employee refuse or accept it? Kind of one of those things. So it's kind of there's no one answer to say here's what you got to do. It really, that's the frustrating part about the ADA in particular, but then this accommodations under Title VII too, is that it really is a tailored sort of individualized assessment. And so I would imagine though, what I've seen at least is that when you decide on an accommodation, maybe lay out the facts, kind of treat it as a contract. Here are the things that you requested. Here are the things that you have identified as conflicting with our employer vaccine policy. And here's what we've come to a resolution, kind of a contract. Lay out the facts and circumstances leading up to that moment. And then maybe just have the employee sign an acknowledgement, not that they agree with it necessarily, but that they've received it to document that everyone's aware of what's going on. So that's kind of what I've seen through the accommodations process. And employers, have developed maybe their own forms through the years, but I would probably approach more of a contractual viewpoint of laying out the facts all in one nice document to sort of memorialize what's going on and what the process was.
Perfect, thank you. I have another one here. We have a client who has a federal contract and falls within the 100 employee mandate for EO. A portion of these employees have nothing to do with the federal contracts. Company has both commercial and federal contracts. Does the employer have to mandate the vaccine for these employees that are not affiliated with the federal contract in any way?
Yeah, federal contracts, that federal mandate, federal contractor mandate is pretty broad. And it's broad because of the way that they defined a covered contract employee. So the way that they defined it, and the answer to your question is it depends. Very, very lawyerly answer here I'm going to give you here. But it is all on the definition of what does it mean to be a federal, a covered employee. There's two tests. One is does that employee, do they work in connection with the contract? So in that particular situation, there's both federal contracts and commercial contracts. If the employee has any dealings, work in connection with a federal contract, then they're covered. They have to be vaccinated. They have to comply. They have to comply with the mandate, federal contractor mandate. You could have employees who have nothing to do with the federal contract and who maybe only work in service of the commercial contracts. So in that scenario, they could still be covered by this federal contractor mandate because they would still be a covered employee if they work in the same workplace as other covered employees. So the test is you're a covered employee for the federal contractor mandate if you work in connection with a federal contract or you work in the workplace, the covered workplace as well. The only time that an employee, so you have an employer with a federal contract, the only time an employee would not be required or would not be covered under that federal mandate would be if they don't come into any contact with any covered employees. So suppose you have an employee, you have multiple facilities, multiple locations, and all your federal contracts are done out of one spot, and at a different facility, you have all your commercial contracts done, then those at the commercial facility are not covered, so long as they're not doing any work in connection with the federal contract. So really the point is that you have to look at your employees and analyze, it's one of two things. Does the work that they do, is it in connection with the federal contract? Even if they do work with the commercial, if they do with at least one federal contract, then they're covered. Or does the employee work in the same workplace as covered employees? Then they would also be covered by the federal mandate. So the injection of a commercial contract is not dispositive. It's really the relationship to the federal contract that is going to determine whether they're subject to the federal mandate.
Okay. All right. I have another one for you. We are a small business and have discussed with our executive team the possibility of implementing a vaccine mandate policy. Some of the questions that were raised is, do we need to provide a paid day off to get the vaccine? And do we have to provide paid time off if the employee feels ill after the vaccine?
Well, I think that the EEOC standpoint is they certainly encourage all that. Federal law and state law certainly does not require paid time off to go either get the vaccine or for any complications from the vaccine or being sick. So so the short answer to the question is no. There's no requirement to do that. But I think the EEOC standpoint is they hope you do. One thing I have seen is sort of kind of give you a guide is to allow employees to go get the vaccine. I think I've seen employers do like 4 hours of paid leave, say just enough time to go get the vaccine and not come right back, but enough time to get their shot, wait in line and do the waiting and all that. So they don't have, they're not offering a lot of time. But in terms of paid leave, now I'll say this, you don't have to offer paid leave, but certainly if they have paid leave, PTO or sick time or whatever available in their bank, paid leave bank or whatever, you can certainly say you can use that as well. But you don't have to offer extra paid leave in order to accommodate the vaccine process.
Okay. For federal contractors, are exemptions allowed? Did you answer that with your last?
Yeah, the exemptions with respect to federal contractors is the same exact thing you have to go through it's going to be medical disability or the sincerely held religious belief, and you go through the accommodations process, see if there is an accommodation, and whether it presents an undue hardship on the business. The rules for that are the exact same with what we discussed here today. No difference.
Okay. I have a client that has many employees, and some work on the contracts that the executive order specifically mandates vaccines. There are also employees that do not work on those contracts, or the employees who are not working on the contracts are required to take the vaccine.
I assume this is federal contracts. So they could. So if you have it sounds like, let me understand. You have some employees who work on federal, but you have some who don't work on any of the federal contracts and just work on separate non-federal contracts.
Correct.
Would the employees on the non-federal contracts be mandated? The answer to get the vaccine under the executive order, the answer is maybe. If they come into contact with the federal contract employees, yes. If they work in the same place, yes. They would still be covered by the executive order mandating federal contract employees be vaccinated. Because of the broad definition of covered employee, it's not just those who work on the contract, it's those who work in the same workplace as well. The only way that you could restrict that, the only way that an employee who doesn't work on federal contracts not be mandated to get the vaccine is if they're working, if they don't come into any contact with the other employees. That could be a situation where they work on a different floor. That could be a situation where they work in a different part of the building, separate and isolated altogether. But if you can determine, that they're never going, if those employees are never going to come into contact with the ones who are working on the federal contracts, then in that limited circumstance, they would not be subject to the federal mandate, vaccine mandate for federal contractors.
Okay, thank you, Andrew. How should we deny or approve a religious accommodation? So I guess they're asking, like, what's the best way to go about that? How should you do that?
I guess, I don't think there's a one size fits all. Really, it really very much is a dialogue. What's the religious? What's the objection? Why are they opposing? And there's multiple vaccines out there now. So it's J&J may be objectionable, but Pfizer may not be. They have to articulate the sincerely held religious belief as to each vaccine as well. So it's not just vaccination that's the problem. It's what is it about these specific vaccines that is problematic and conflicts with, and then that's the second part. What is the religious belief? What is the religious practice or what the religious observance that the vaccination is coming to conflict with? They have to. I think that's where the employee may not be able to express that right away, and that's why you want to have a dialogue with that employee to really get that information out and to understand what it is what is the basis of it. You could also maybe ask for if it's possible, I don't know in a religious context whether it's possible to get documentation, but let's suppose they have that hurdle they pass that hurdle or you sort of accept it as a sincerely held religious belief, practice, or observance. Then the next part of it is to say, well, what's the accommodation? So if they're objecting to the J&J vaccine, I think this is what it was. The J&J vaccine, or maybe the Pfizer one of them uses like stem cell research. And stem cell research is a basis of objection for religious-based objections. And so it's like, okay, well, fine. If it's the stem cell issue that you're concerned about, well, then let's look at the J&J vaccine. They don't use stem cells, or something like that. I forgot what it was. But so maybe the accommodation in that respect may be just getting a different shot, not the one that they're objecting to. So it's kind of just documenting. That's why you want to learn about it, because then you can say, okay, well, in documenting, I'm just saying, it could be something simple as a note or a memo and saying just put it in in with the request. Kind of the way I imagine it is, I'm trying to find a folder here. You have an employee that you got a sheet of paper with their request. You got a sheet of paper saying, well, here's something, so you kind of just document a memo to the file to say, here's what we've offered, or here's what we've sort of identified as a possible accommodation. So that's sort of documenting, and then letting them know, again, a simple letter would be fine. I would, there's no magic language or magic, anything specific or particular you need. It's just really more the substance of saying, here's the accommodation that we have decided that you can do. If your objection is based upon how it's manufactured, well, let's find a different vaccine that's manufactured in a different process that would not conflict with your religious belief. You kind of just want to document, here's the analysis that we went through, and really just a memo to the file may be sufficient on that.
Okay, I've got two more here.
Okay.
Is it legal for the employer to request medical documentation from a doctor?
You can explore the medical condition. You would want to have the employee provide that to you. But yeah, that certainly is permissible to do. Is to request what's the medical condition at issue, the disability at issue, I'll say a doctor's note, but having a medical opinion on that from their provider is certainly acceptable to ask the employee to provide, for sure. There's nothing wrong with that.
Okay. And then I have, if an employee is not directly involved or works under the federal contract, does the employee have to get vaccinated? So I think you did answer this, earlier.
Yeah, they could be. It's funny when we talk about directly involved, that sort of depends upon, let's say this, you could have a federal contract to go, I'm going to make up something here, go build a building. But the one thing to also note is that people in HR, people in billing, people in the legal review of those contracts would be in support of that federal contract. So they may not actually be working directly on the contract. The employees could be covered by indirect work on the contract or in support of the contract. So you want to be, when you classify your employees as either working on a federal contract or not, if their work is necessary to implement or execute the contract, they would be covered as a federal contractor. If they have nothing to do, they don't even support the contract with an HR side or indirect support, they could still be covered under that mandate, could still be considered a federal worker, contract worker, if they work in the same workplace as other covered employees. So that's the second part to be mindful of. So it could be.
I have one more that came through.
Sure.
Did you say tests will have to be at employer expense in Louisiana?
Wait, I'm sorry. My speech is cut.
Do the COVID-19 tests have to be at the employer's expense in Louisiana?
Yeah, Louisiana is one of the states that does require that if the employer is going to mandate testing, require it of their employees, then the employer's got to pick up the bill for that. They can do it by way of a reimbursement, let the employee pay, and then just submit their receipt. That's a fine way to do it. But at the end of the day, the cost should be on the employer to pay for that test. Yes, in Louisiana. If you're an employer who has employees in Louisiana, but you want to have others tested in another state, then you have to follow the rules of that other state that they work in.
Okay. All right. Well, it looks like that's all the questions I see. Okay. Andrew, I can't thank you enough. I mean, we've had a lot of interest here, and I know that the people who were on, I'm sure they got a lot out of it. I do want to let the audience know that once we end the webinar, there will be a survey sent to you. We would appreciate if you would answer that. It kind of gives us an idea of how what you need moving forward, what topics you need, and if the MEP can help you. Please let us know if we can. You can always contact us, especially via email, mep@mepaw.org, or just go onto our website and contact us there. Again, Andrew, I just want to say thank you. If any of you do need employment law help, you can absolutely come through the MEP. We will connect you with Andrew, and we would be happy to help. So thank you so much. And if anyone has any questions as well, please reach out to us, and we'll get those answered.
All right. Appreciate it very much.
Thank you, Andrew. All right. Bye-bye.